Many families assume if you have power of attorney, you can automatically handle Medicare for someone. That's not always true. And if you don't know the difference before a crisis happens, you can lose time and options. Before we talk about Medicare, let's clarify what a power of attorney actually does. A power of attorney, often a durable power of attorney, is a legal document created under state law that allows someone to act on your behalf. There are different types. A durable power of attorney typically allows someone to manage financial and legal matters, and it can remain in effect even if the person becomes incapacitated. A medical or healthcare power of attorney, sometimes called a healthcare surrogate, generally allows someone to make medical decisions if you are unable to do so. These documents give authority under state law, and in most cases, they must be properly executed, often including notarization, to be legally valid. But here's where confusion begins. Having a power of attorney does not automatically mean every federal agency, including Medicare, will immediately speak to that person. And that's where we need to go next. Now let's talk about what Medicare actually requires. Medicare operates under federal privacy rules. That means even if someone has a durable power of attorney, Medicare may still require its own written authorization before discussing personal information. If someone simply needs Medicare to share information, such as coverage details, claims, or enrollment status, Medicare uses a form called CMS 10106, Authorization to Disclose Personal Health Information. This form allows a beneficiary to give Medicare written permission to speak with a named individual. It's about information sharing. Now, if someone needs to formally represent a beneficiary in a claim, appeal, or grievance, Medicare uses a different form called CMS 1696, Appointment of Representative. This form allows someone to act on behalf of the beneficiary in certain Medicare matters. And this is important. Verbal permission over the phone is not the same as legal authorization on file. Without proper documentation, Medicare may decline to share details, even with a spouse or adult child. Timing also matters. If this paperwork isn't in place before an enrollment deadline or appeal window, valuable time can be lost. That's why understanding Medicare's authorization process before a crisis is so important. Here's what I often see. Not because families aren't responsible, but because no one explained this clearly. The caregiver blind spot usually shows up during a crisis, a hospital stay, an enrollment deadline approaching, an appeal that needs to be filed quickly, an unexpected IRMAA issue, or a prescription drug plan that suddenly changes. In those moments, families are trying to solve multiple problems at once. And when authorization paperwork isn't already in place, it creates unnecessary stress. This is why planning before 65 is strategic. Having a power of attorney in place is a good thing. It's responsible planning. But Medicare plays by its own rules, and sometimes that means there's one more step involved. The goal isn't to figure this out in the middle of a hospital stay. It's to have it handled before you ever need it. If you'd like to see the official forms, you'll find links to both in the description below. If you're supporting a parent or planning ahead for Medicare yourself, getting clear answers early can prevent unnecessary stress later. And if you're in Florida and would like a Medicare review conversation, you're welcome to schedule one using the link below.